some part of the decision in the matter of Paul K. Semogerere and others versus the AG. This is a decision from Uganda wherein they discounted the Kesavananda decision, and this is what they said. Those who frame the Constitution also know that new and unforeseen problems may emerge. That problems once considered important may lose their importance because priorities have changed. The solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification. That judicial interpretation may rob certain provisions of their intended effect. That public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitations on the amending power because the end of a Constitution is the safety, the greatness, and the well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. There is also the other decision from Uganda, Male, Mabarizi, and others, which of course also discounted the doctrine of basic structure. So in my view, the above decisions from Malaysia, Singapore, Zambia, Uganda, and Tanzania demonstrate that the courts have rejected the doctrine of basic structure on the reasoning that a constitution, being a living document, must inevitably change as society progresses. That a living constitution must be flexible to allow for a country's growth, and the review of a constitution is essential so as to cater for new and unforeseen future problems, and hence it is inadvisable to have a constitution cast in stone. To my mind, I have no illusion whatsoever that the Kenya's constitutional past was indeed a dark past. The pre-2010 constitution was misused and abused for selfish political gains. Several instances stand out. In 1974, Paul Ngei, the then minister in the late President Kenyatta's government, was found guilty of an election offense and by operations of the law was barred from running in the ensuing by-election. To save him, His Excellency, the late President Kenyatta, passed into law a bill tabled in Parliament and passed into law in a single afternoon, pardoning Honorable Paul Ngei of an election offense. Then there was the 1982 constitutional amendment that dealt a death blow to multi-party democracy and turned Kenya into a de jure single-party state of the then all-powerful Kenya African National Union. The reason for the hastily carried out amendments or dismemberments of the pre-2010 Constitution are not difficult to discern. The power to amend the Constitution was provided in Section 47 of the pre-2010 Constitution, and this power was reposed solely in Parliament to the exclusion of the proverbial Wanjiku. I have cited the provisions of Section 47 of the 2010 Constitution. Our pre-2010 Constitution, like the Indian Constitution, did not bar amendability. It is against the backdrop of the Indian Constitution, where there is no provision for amendment of the Constitution by the constituent power, but the power to amend being reposed solely in Parliament, that the Kesavananda decision was made. In his scholarly writings, Yaniv Rosnai traces the history of the basic structure doctrine and how it was developed in response to Prime Minister Indira Gandhi's attempt to amend the Constitution. He states, "The Indian Constitution lacks any unamendable provisions. Also, Indian jurisprudence, rooted in British tradition, initially rejected the notion of implicit unamendability. That position